Welcome to Corporate Law CL4. As you know, we have now completed our syllabus, and I have taken you all through all the important areas pertaining to the company law or the law relating to corporations in Sri Lanka. And today we will be attending to some questions and answers that I have based on the pilot paper that was provided by the Chartered Accountants Institute. So I will be basically touching upon the questions, and I'll be showing you how to answer and also to clarify and explain the answer, especially with regard to the multiple choice questions, the MCQ ones, where I will be showing you the answer as well as giving certain explanations. And for the problem questions, I will be explaining on how to provide a good answer for your question paper. So let me now take you through the pilot paper and the answers what I could explain to you in how to answer these questions. Now you may see first of all that the time allowed is 3 hours and 15 minutes, where you will be given 15 minutes to read and plan yourself, and then to write the answers in 3 hours. There will be a total of 100 marks given for the paper, and you are required to answer all the questions. All the questions of the two main parts, part 1 consisting of section 1 or the MCQ or the multiple choice questions, and the other sections on problem questions. So this paper consists of 3 sections therefore. Section 1 has 10 questions, the MCQ ones carrying 2 marks each, and section 2 consists of 4 questions carrying 10 marks each, and section 3 consists of 2 questions carrying 20 marks each. So that is how all total of 100 marks are distributed. Answer should be in English language in the answer booklet given to you, and begin each answer on a separate page in the answer booklet. This is very important, that you need to begin each answer on a separate page in the answer booklet and submit all workings once you complete your question paper. Now when we go to section 1, the first MCQ question is that a company should give a public notice of its incorporation, and you need to find the best answer or the more correct answer to this question. The question is, the company should give a public notice of its incorporation. Now I have told you when we were doing on the incorporation of a company, the first most important thing in incorporating a company is where the articles of association are to be provided along with the necessary forms as per the registrar of company. Now when you are incorporating a contract, I beg your pardon, a company, then there is a specific time period within which you need to give a public notice to the general public by putting out newspaper notices as required by the Companies Act. So, when your company is to be incorporated and you apply for the incorporation of your company, then you need to give or publish a public notice in general newspapers of 3 languages, Sinhala, English and Tamil, within a certain time period. The question here is, within what time period that you need to give such public notice? The answer to the question is that within 30 working days, which is answer A. Within 30 working days, you need to give public notice in the prescribed form. And what is important here is that the 30 days to be counted is based on the working days. Now, I have explained to you what are these working days as per the Companies Act in Sri Lanka and in my lectures. So, working days would mean any day except Saturday, Sunday or any other public holidays announced by the state. Now, one important thing we are experiencing right now is the COVID period. And we know during the past few months, we have been having curfew, government imposed curfew. Now, during such time, the government informed that even the weekdays where the curfew were imposed, they cannot be considered working days because the country was in lockdown. So, therefore, if your incorporation happened during this period and as per the company's law, you are required to publish the public notice within 30 working days, you can simply ignore the days in which the curfew was enforced. So, therefore, unlike in a situation of a curfew, normal working days would mean except Saturday, Sunday, any other public holidays announced by the state, including the POE days and days of curfew. Now, the second question here is second MCQ. The certificate of incorporation of AB Private Limited was dated 6th of January 2019. However, in fact, it was signed and issued on 8th of January 2019, just 2 days after the incorporation was issued or given. On 6th of January 2019, the company allotted shares to a prospective shareholder. Now, select the correct statement. Now, here the problem is based on a situation where a company incorporation was affected on the 6th of January 2019, but it took 2 days to sign the incorporation certificate and issue the same, which took place on the 8th of January 2019. But however, with the incorporation being announced on 6th of January 2019, the company allotted shares to a prospective shareholder. The issue here is whether such allotment of shares is valid or invalid. Suppose the incorporation was not made effective on 6th of January, but rather on the 8th of January, then the allotment of shares is invalid. However, the signature and issuance date being 8th of January is irrelevant to the company being incorporated, because the certificate of incorporation was dated by the ROC, the Registrar of Companies, as 6th of January. That is to be considered the date of incorporation and not the signing or the issuance date. So, therefore, shares issued on the 6th of January are to be valid. So, in view of that, the correct statement would be C. The company came into existence on 6th of January 2019, and I have illustrated here that the date of signature or issuance is irrelevant as far as the register maintained by the Registrar of Companies has an entry that the incorporation was granted on a particular date. So, the date on which the incorporation of the particular company was granted is considered the real date of incorporation. It is not the date of signature or the issuance. It is the date that is indicated in the certificate of incorporation as the date of incorporation, which is considered the valid date of entry into force or into effect of this particular company. Now, let us go to the third question. It is, if the name of a company is XYZ Limited, it is what? Now, I have told you in my lecture series that the nature of the incorporation of a company would determine the style in which its name should be carried. Whatever the name that you give to the company is the company's name that starts with. So, if your company is named as XYZ or ABC, whatever, the company's name first of all must carry the name that you are giving, which is XYZ or ABC. Then, if the company is a limited liability company, then you must include the term limited, because the liability of this company is limited. It could be limited by shares or limited by guarantee, as you know. If XYZ is a private company, then the name and style of that company would be XYZ Private Limited. If XYZ is a listed company, then XYZ PLC or Public Limited Company. Now, in this case, XYZ Limited does not denote that it is a private company, because the term private is not there. It is also not considered a listed company, because it is not referred to as a PLC or Public Limited Company. XYZ just states as limited. Then, if you look at D, it is also not an unlimited company, because the word limited is there. It does not say XYZ Unlimited. It says XYZ Limited. Therefore, the correct answer is C. It is an unlisted company. So the answer to question 3 is that it is XYZ Limited is an unlisted company as given in answer 3. Generally, private limited companies are referred to with private limited at the end, while public limited companies take form of LTD only when that is unlisted public company. When a company is listed, it takes form of PLC in the case of public limited company, while all other referred with just the company name without any inference of private or PLC in the case of a limited company is an unlisted company. Unlisted company. Now let us go to question 4, where the question is, which is not a feature of a private company. Now this question examines you whether you understand what is a private company in general. Now there are 4 answers given. Unlike the questions that we did before, now this question 4 gives you 4 choices where you need to select which one does not refer to as a feature of a private company. Now if you look at the first one, there can be a maximum of 50 members. Now we know, having gone through our lectures, a private company can have a maximum of 50 members. So therefore, answer A is right, but it is not right as far as the question is concerned, because the question is which one is not a feature, not right. Right? If you look at B, it need not to deliver financial statements to the register of companies. Now you know the private companies, by virtue of the law, the Companies Act, needs to deliver the financial statements annually to the register of companies. So B is also not the answer question 4 is seeking. Then C, it may by a unanimous resolution of the shareholders dispense with keeping interests registered. Now if a particular private company wants not to keep interest register, it can do so as long as its articles permit so by unanimous resolution of the shareholders. The shareholders can resolve that the company need not keep an interest register. So which means that C is also not the correct answer. D, it may by a unanimous agreement any decision can be taken even if such a decision may contrary to the Articles of Companies Act. Now here we know that a company is obliged to follow its Articles of Association, because Articles of Association is the constitution of the company, and therefore the company cannot act contrary to the articles, the company cannot derogate from the articles, and apart from the articles, the company is also obliged to follow whatever said in the Companies Act, or rather the company's law. So if the company has taken an unanimous agreement that any decision can be taken in contrary to the articles or the Companies Act of Sri Lanka, then we know that it cannot be done. So therefore, the answer to the question 4 is D. Now, I have clarified that here, where I have mentioned that answer to question 4 is D. It may by a unanimous agreement, any decision can be taken, even if such a decision may contrary to the Articles of Companies Act, which is wrong, which is not a feature of a private company. A private company, I have illustrated that, a private company can neither bypass its Articles of Association or the Companies Act in Sri Lanka, as these are the two main regimes that govern the company, the private company. The articles cover the internal governance of a company. We know that it's the constitution of the company, so therefore the articles cover the internal governance of a company, how to manage the internal affairs of a company. While the state law, which is the Companies Act, presently number 7 of 2007, has an overall corporate governance of the area of company law in general in Sri Lanka. So therefore, a private company can neither bypass whatever said in the articles nor the Companies Act. Now, I have further clarified and explained why the other answers do not match. If you consider the other answers, A is a feature that maximum number of shareholders in a private company can extend to 50 numbers shareholders, while B is also a feature as it is the duty of a private company under the Companies Act to deliver its annual financial statements to the Register of Companies. C is quite relaxed provision where a private company could dispense with the keeping of an interest register at the will of the shareholders, so that they could arrive at such discretion by way of a unanimous resolution, as long as it is not contrary to the company's articles, and such articles so provide the liberty to the shareholders to act in such a manner. So therefore, none of the answers A, B, C are correct in the question. So the correct answer is D. Then going to question number 5. Who shall be capable of being appointed as a director of a company? You may remember in my lectures, I dealt with the qualification and disqualification of directors. There I gave a huge list or exhaustive list of disqualifications and qualifications of a director of a company. Now, if you go to that particular section we did, I have here illustrated that first of all, here the answer is quite tricky, right? So before I go to the answer, let me clarify this area, section 202. As a director of a company can be anyone as per section 202. Those who have attained the age of 18 years are eligible to be a director. Who is not declared as insolvent also, or a bankrupt, also eligible to be a director. Thirdly, who was not prohibited to act as director under the former law, that is the Act number 17 of 1982, is also eligible to be a director. Fourthly, who was not prohibited to act as director or promoter by virtue of operation of section 213 or 214 of the former law, or Act number 17 of 1982, is also eligible to be a director. Fifthly, anyone who is not adjudged a person of unsound mind or having an insanity or crazy, those who are not adjudged, that means pronounced by court, a person of unsound mind, anyone who is not like that or do not fall to that category is eligible to be appointed a director. Then anyone who is a natural person is also eligible. Here why we are saying that natural persons are only eligible, because body corporates are not eligible to become directors of a company, even though body corporate can be a shareholder in a company. Then anyone who is not qualified under the articles of the company, if the articles don't permit somebody to be director, then he is not eligible, which means that if the articles do not prohibit anyone becoming a director in the company, then he or she can be appointed a director. Further it says that who has not been convicted of an offence punishable by imprisonment under the present Companies Act, but to a period of lapse of 5 years from the date of such conviction or pronouncing of the sentence, will be eligible. So those who have may have been convicted of an offence, imprisonment under the present Companies Act, but after 5 years of such conviction, he or she may be eligible to become a director. Then, who has not been convicted of an offence involving dishonest or fraudulent act, but until lapse of 5 years, and therefore, when we go back to the question, who shall be capable of being appointed as a director of a company, having those what we discussed just now in mind. Now what they are asking here is, who shall be capable of being appointed. Now in the first one it says Soma is 17 years old minor. Can Soma be appointed a director? No, because Soma is only 17 years and still a minor, not attained the age of 18. Second one, ABC PLC is a duly incorporated company under the Companies Act. I told you only natural persons can be made directors, not body corporate. So therefore ABC PLC, which is a body corporate, they may be having shares in this company, but still that company cannot be made a director. Third, Raja had been convicted 6 years before for an offence of fraud. Now for fraud I mentioned, from the date of conviction up to 6 years, up to 5 years, that person cannot be appointed a director, but after 5 years from the date of the conviction or the sentence being made, that person is eligible to be a director. So C is correct. Raja can be appointed a director. Then D, Kamal had been convicted 3 years before for an offence of fraud. So Kamal does not qualify to become a director because he has still not yet passed the 5-year requirement after having been convicted of the offence of fraud. Now here I have clarified, here the answer is quite tricky. Even though answer is C that we have selected is right, it is quite tricky. Careful consideration should be had to the words had been convicted here, right, not has been convicted. Has been could even be present tense, but had been is past tense, and the word before, 6 years before, which means the time has lapsed. So, which means that the sentence has been, or the conviction has been over by now. So, therefore, the correct answer is C, as the rest of the answers fall into disqualification category. Then let us look at question number 6. According to the Land Restrictions and Alienations Act number 38 of 2014, the transfer of title of any land situated in Sri Lanka shall not be prohibited if such transfer is made, and 4 answers are given where you have to select one. Now, what is important in Land Restrictions on Alienation Act number 38 of 2014 is that in Sri Lanka, acquiring or owning lands, Sri Lankan lands, by foreigners or foreign entities have been prohibited. So, therefore, this 2014 Act prohibits foreigners or foreign entities to own Sri Lankan land. And when it comes to transfer of title to any land situated in Sri Lanka, what is prohibited and what is not is what we have to select here. So, answer A, to a company incorporated in Sri Lanka which foreign shareholding is 50 or above. Now, in Sri Lanka, a company having 50% or more shareholding held by foreigners or foreign entities, such company cannot own lands, and no land can be transferred as to its title or ownership to such a company. So, A cannot be taken as an answer to this question. Then second one is to a foreign company. Now, I have told you that no foreign entity can obtain the transfer of title of any land situated in Sri Lanka. So, therefore, answer B is also wrong. Then C is to a foreigner. Again, I told you that no foreigner can own or have a transfer of title of any land situated in Sri Lanka under this Act. And D, so C is wrong. D, to discharge of a mortgage to any licensed bank in which any foreign shareholding is 50% or above. Now, this particular statutory act, Land Restrictions on Alienation Act number 38 of 2014, does not prohibit the discharge of a mortgage to any licensed bank. That means keeping a land on mortgage with a licensed bank. So, even a foreigner or a foreign company that has shares in a company, that company can transfer the title of any land owned by that company as a matter of mortgage, obtaining a loan from a licensed bank in Sri Lanka, irrespective of the fact that the foreign shareholding is 50% or above in that company. So, how I have explained the particular answer here is answer 6. D is the correct answer, to discharge of a mortgage to any licensed bank in which any foreign shareholding is 50% or above. Since lands in Sri Lanka cannot be disposed to a company having majority of its shares to foreign ownership under the prevailing law, the Land Restrictions on Alienation Act number 38 of 2014 only provides the possibility of a mortgage to any licensed bank in Sri Lanka. Therefore, all other answers are incorrect, whereas none of them cannot be made possible under the said prevailing law of the country. So, what is important here in this question is that the Land Restrictions on Alienation Act number 38 of 2014 has prohibited the alienation of land or transferring of ownership or title of lands in Sri Lanka to companies having majority of foreign shareholding, foreigners or foreign entities. Then let us look at the next question, number 7. The Secretary of a foreign shareholding company shall inform the percentage of the total number of shares issued to Registrar of Lands in writing in every which period commencing from the date of registration of the transfer deed. Now, this is connected to the earlier said statutory provision, the Lands Alienation Act, where any company having foreign shareholding must inform the Registrar of Lands, who is the authority, main authority under that act, that about the details about the lands that have been acquired or owned by such company in Sri Lanka. Now, the question is, how often or in what period of time that such information needs to be given to the Registrar of Lands. Now, what is important here to note is that the Secretary of the company must keep informing the Registrar of Lands due to the statutory implementation of that act, that wherever or whenever there is foreign ownership in a company in Sri Lanka, the lands that holds lands in Sri Lanka of the total number of shares issued to the foreign shareholding. So, the Secretary of a foreign shareholding company shall inform the percentage of the total number of shares issued to foreign shareholding to Registrar of Lands, so that the Registrar of Lands will know as to what sort of ownership that this company has in lands located or situated in Sri Lanka. Earlier we know that foreign company or company having majority of foreign shares cannot own lands. So, this is the point where the Registrar of Lands can check whether companies owning lands in Sri Lanka have majority foreign shareholding or not. And such communication or reporting has to be done every period of interval. The answers given here are 12, 18, 6 months or 3 years. And the correct answer is 6 months. Every 6 months, the secretary must inform to the registrar of lands of the foreign shareholding in that company. Answer is 6 months. It is the duty of the secretary of the company that is having foreign shareholding to inform the registrar of lands on the shareholding by foreigners or foreign entities in order to comply with Land Restrictions on Alienation Act number 38 of 2014. Since foreigners and foreign entities cannot hold lands under the said law, the said duty is casted on the company secretary to keep the registrar of lands informed of the same. Now, in both these questions, since this foreign shareholding was in question, in both these questions, I need to say that, however, this is in contrast to section 490 of the Companies Act that allow registered overseas companies to hold lands in Sri Lanka. As far as section 490 apply, we need to follow what is there. Therefore, care should be had to the question as to how it is put. The next question, or rather next two questions, is based on the Exchange Control Act. Question number 8 and 9. 8, the outward investment limit of a listed company. That means currency going out from a listed company to purchase shares of an overseas company is, or an equivalent amount is what? Or an equivalent amount in any foreign currency designated by central bank per calendar year. So, per year, how much of money can go out of Sri Lanka from a listed company in order to purchase shares of an overseas company? So, you have to be very careful in answering this, because the question is the outward investment limit of a listed company to purchase shares of an overseas company. Per year is USD 2 million. The answer is 2 million. Answer here is 2 million. This derives from exchange control law that the outward investment limit of a listed company to purchase shares of an overseas company is limited to USD 2 million or an equivalent amount in any other foreign currency, whether it's euro or sterling pounds. It is the USD 2 million that you need to convert to that particular currency and see how much would be in that particular currency, such as euro or sterling pound, and designated by the central bank per calendar year. So, for a year, you can remit 2 million outflow from the country by a listed company to purchase shares of an overseas company. This is to ensure that the flow or repatriation of funds from Sri Lanka is conducted in a controlled environment. The next question is also based on the same law, and it is the outward investment limit of an unlisted company to purchase shares of an overseas company So, outward investment limit now of an unlisted company to purchase shares of an overseas company is pretty much below the figure that we answered for question 8 as US dollars 2 million. Per year, you can only take out 500,000 USD. The answer is C. This also derives from exchange control law that the outward investment limit of an unlisted company to purchase shares of an overseas company is 500,000 or an equivalent amount in any foreign currency designated by central bank per calendar year. Again, it is to ensure that the flow or repatriation of funds from Sri Lanka is conducted in a controlled environment. It should be noted that answers 8 and 9 are related to different scenarios, as 8 refers to listed companies while 9 relate to unlisted companies. Therefore, the limit in respect of a listed company is much greater than an unlisted company, so as to encourage foreigners and foreign entities to invest in the stock market in Sri Lanka. That is the rationale here. That is the rationale. To let the stock market in Sri Lanka grow. Now, to question 10, the last question of the MCQ, and it is any person resident outside Sri Lanka may invest in shares of a company incorporated in Sri Lanka only up to what percentage of the stated capital of such company. Now, here the question is any person resident outside Sri Lanka. So, citizenship does not matter at all. As long as that person is resident or domiciled outside Sri Lanka, the amount of percentage of the shares that that person can invest in a Sri Lankan company is, the answer is 40%. The shareholding ratio as per the law in respect of local and foreign shareholding there is 60:40, where the maximum percentage of shares that a non-resident in Sri Lanka can hold is 40, and those who are living in Sri Lanka locally can therefore own in that particular company 60% of the shares. If there is a foreign part, if there is a non-resident partnership, non-resident participation in the shareholding, that non-resident shareholder can take up to 40% shares while keeping the 60% to the local participation. Therefore, foreign shareholding shall be restricted to 40% for company that attract shares to foreigners or foreign entities who are resident outside Sri Lanka. This would, however, not only in case not apply in cases of offshore companies and overseas companies that fall within the provisions of the Companies Law of Sri Lanka. And also it is not with regard to the owning of a company, but a non-resident can only invest in 40% of the stated capital of the company. Now, going to section 2 of the question paper. Now, these are more problematic questions that require some detailed answering by you. Now, first question, I think I have done this also in my lecture series, but I will be revisiting this in this model paper. A company was incorporated by the name Pothala Private Limited. Its business is selling school items at Colombo. Later, another company was incorporated by the name of Colombo Pothala Private Limited. Its business is also selling school items at Colombo. The first registered company, Pothala Private Limited, came to know about this fact after publishing the public notice of the second registered company. The first registered company, Pothala Private Limited, is seeking a possibility to prevent the secondly registered company by using the words Pothala as part of its name. You are required to advise the first registered company, Pothala Private Limited, by considering the provisions of the Companies Act. Now, before I go to the answer, I need to tell you that in answering such a question, you need to elaborate the law, because this is a law paper, and also you need to illustrate and explain what sort of advice that you can give, because you are required to advise, not to analyze. You are required to advise. So you got to be very to the point in giving your advice. Now, you know that in this area of company names, you cannot incorporate a company with the same name or similar name as of an existing company name. So, in answering this question, what I have given you or now going to show you is somewhat an illustrated answer. But I do not know how many of you all will give a full illustrated answer in your question paper, answer paper, because you may be fighting with the time. If you cannot illustrate like an essay, then my advice is to write it in point form, point by point. If you are not good in writing essay type, then use the point form. As long as what you say is correct as per the law, you will be getting the marks. So, what you got to do is to write the proper sections and the proper statements, as you all have now covered this area lengthily. Now, if I may to answer, I would provide this answer in this manner. According to section 2(1) of the Companies Act, number 7 of 2007, a company incorporated under this act shall, by the name by which it is registered from time to time, be a body corporate. Now, this is what section 2(1) says. First of all, a company incorporated under this act shall by name. Now, this is where the term name comes, by which it is registered from time to time. So, you got to register a company by name, that is very important, and to be a body corporate. The company must have a name. Now, further section 7(1) says, a company shall not be registered by a name which is identical with the name of any other company or of any registered overseas company. I mean, registered in Sri Lanka, overseas company registered in Sri Lanka, as we know. Or subsection C says, is in the opinion of the registrar misleading. Now, I have omitted B, C, B, D and other things because I want to concentrate on the more relevant provisions here. So, I am only taking out A and C. A says with a name identical with the name of any other company or of any registered overseas company, or is in the opinion of the registrar misleading. Now, in this question, the names Pothala Private Limited and Colombo Pothala Private Limited are identical, and also the businesses of both these entities are similar in nature, while they both operating within the same geographical jurisdictions of Colombo. Generally, the registrar of companies shall not register a company having similar name. So, that is why prior to the registration or incorporation, prior to the registration by the ROC, you are required to make a public notice in the newspapers, so that anyone who has an objection can thereafter bring the objection. And if he does so, the first company can move its objections to remove the second company from the register of companies by making a protest to the ROC, Register of Companies. The existence of the two companies would lead to confusion among the customers and general public, because the names are pretty much similar, except the fact that the second one has the term Colombo in front. But both companies going to operate in Colombo and on the same business of selling books. So, therefore, the existence of the two companies would lead to confusion among the customers and general public, so that it runs into misleading scenario. Therefore, the first company must take action to duly protest against the registration of the second company without any further delay after getting to know the existence of the second company, because those who are protesting or objecting have a prescribed time limit to do so, to object or to protest. So, therefore, protest or objection must come within the prescribed time limit. So, you must do it duly. So, this is the advice that you can give. Analyzing the law, you are giving the advice to the first registered company, the Pothala Private Limited. In the second question of part B of question A, Amal and Kamal are going to incorporate a limited liability company under the Companies Act. What are they going to incorporate? A limited liability company. They have decided to name the company as Ranmuthu. We are required, as per the Companies Act, explain how the proposed company's name should be mentioned in full. Now, since this question related to the name of the company, I also visited the name Ranmuthu as well. But if you are in a hurry to finish your paper within the time limit given, and you run out of time, I would not advise you to pay much attention to the name Ranmuthu, because what you have been asked is to write the proper name of the company, or write the proper name that this company should have. So, Ranmuthu blah blah blah, whatever. Right. But I have in fact illustrated in my illustrations very lengthily, which either you can take it or you can only do the latter part as I mentioned. Now, what I have told is, in first place, the name Ranmuthu is acceptable to the ROC as long as there is no previous incorporation of a company having the identical or similar name, while it is not misleading to an existing company registered under the Companies Act. Since we have restated that in the first answer, you may not need to revisit that. As indicated in the previous answer, under section 7.1, a company shall not be registered by name which is identical with the name of any other company or of any registered overseas company, or it contains the words Chamber of Commerce unless the company is company which is to be registered under a license granted under section 34 without the addition of the words limited to its name, or C is in the opinion of the registrar misleading. Further, a company shall not be registered as per section 217.2 where no company shall be registered by a name which contains the words president, presidential or other words which in the opinion of the registrar suggest or are calculated to suggest the patronage of the president or in connection with the government or any government department, municipal, incorporated or any or other words which in the opinion of the registrar suggest or are calculated to suggest in connection with any municipality or other local authority, with any society or body incorporated by an act of parliament, cooperative or society or national state or Sri Lanka or other words which in the opinion of the registrar suggest or are calculated to suggest any connection with the government or any government department. Now, if you need not go into much detail of the word Ranmuthu, you can omit this, but if you would like to touch upon this with the idea and anticipation of gaining more marks, right, you can really give explanation to this effect, because you know that this question carries 10 marks, right. And here the question says that for the first part is 5 marks and for the second part is 5 marks here. First part you know that it was quite a large extent we had to discuss, but second part is not, though it looks small, it also has equal weight of the marks. So, therefore, might as well give a good answer, a long answer like how I have explained. So, therefore, does not seem to exist of any impediment in registering the company in the name of Ranmuthu as required in the question. Since the company is a private limited liability company, it should be named as Ranmuthu Private Limited. Ranmuthu Private Limited. So, suppose that you only want to write this part, you see that it is very small and you can very simply do it, but the examiner might not prefer to give you full marks of 5 if you only write this. So, that is why I thought that in order to explain how to gain more marks, to give more illustration as to the entire question. Then let us look at the next question, question 3, which also has 2 parts with equal weight of marks, 5, 5. Now, the question is, the affairs of ABC Limited are being conducted in a manner oppressive to the minor number of shareholders. In addition to that, due to the material change in the management of the company, some affairs of the company are likely to be conducted in a manner prejudicial to the interest of the company. Further, the directors of the company are going to engage in a conduct which is against the articles of the company. Now, in my lecture series, I covered the area of operation and mismanagement, and I have explained to you that this area is very important because the shareholders or directors in a company might be acting in a manner prejudicial and to the detriment of the company's interest, and in a way where the company directors are acting in favor of the majority shareholders, thereby creating an unduly prejudicial way towards the minority shareholders. The minority shareholders really has a opportunity to take the company to court, complaining of oppression and mismanagement committed by the management of the company. Now, in a company, generally the directors either work more towards the favor of majority, or in the case where company directors are appointees mainly of the majority, or that the directors are in fact majority shareholders. So therefore, in this question we will have to touch upon the minority's right, and it is the same thing that I see in the questions that they are asking as A, explain the majority rule principle and its exception, the minority protection, and B, they explain who can make an application against oppression and mismanagement. So now, if you look at these two questions, A and B, these are very heavy. These are very heavy and carry equal amount of marks, because both questions are heavy as each other. So, in doing so, I have provided a very comprehensive answer, So, I have provided the answer to question A of question 3 as where I have explained that the majority rule principle is that the will of the majority of the members of the company should in general prevail in the running of its business. Those majority shareholders believe that they can do anything, risk more and more, since they find themselves unpunished while remaining within the very large margins of the law. However, the abuse of minority shareholders come mainly from the greed of some of the majority shareholders, who in some cases has no limit. A minority shareholder is defined as a shareholder who does not exert control over a company. The majority shareholders almost always exert an absolute control over the company, its management, its board of directors, and so on. The definition of minority shareholders will include those shareholders who do not exert control over the board of directors of the companies, even if together they own the majority of shares. And the majority shareholders are defined as those who control the board of directors of the company, even if effectively they own much less than the majority of the shares. This is where the exception that lies in the protection of minority shareholders come into play. In order to protect minority shareholders, Section 99 of the Companies Act imposes restrictions that companies shall not take any action that would affect the rights attached to shares, unless that action has been approved by a special resolution of each interest group. The rights attached to share include the rights, privileges, limitations and conditions attached to the share under this Act or the articles of the company, including voting rights and rights to distribution. Then preemptive rights, then procedure involving minority buyouts and any further procedure required by the articles of the company for the amendment or alteration of the articles observed by the company, and the right that a procedure required by articles of the company for the amendment or alteration of the articles not be amended or altered. So this is how you need to answer the first one, where the first question there is on explain the majority rule principle and its exception, minority protection. Second one is explain who can make an application against oppression or mismanagement. Now, though it looks quite easy, quite straightforward, we need to analyze the answer with the relevant statutory provisions. So, that is why I have given a detailed answer here too. Due to the possibilities of the management of a company could act in oppression and mismanagement, the majority rule had certain exceptions to it, thus affording remedy to individual members in common law. Where the act complaint is illegal or ultra vires the company, where the act done by majority inflicts fraud on the minority, where a resolution is passed by a simple majority for any act which specifically requires a resolution by special majority, and an infringement of individual rights of a member. While there is no consistent link in the various judgments, it can be safely said that the English courts have abandoned their traditionally conservative approach towards allowing such petitions by giving the provisions of wider interpretation, thereby increasing the access to justice. Because these provisions come from English law. So, that is why I have laid some of my justification on the English law. The first case is the landmark judgment of Scottish Cooperative Wholesale Society Limited versus Mayor, where it was held that recourse to section 210 of the English Company Law Act at that time was possible when it was shown that the company was suffering damage and that remedy under the section was not barred in case of minor operation. This judgment significantly increased the scope of the recourse available by watering down the requirement of proving that the company must be wound up. Further, I go on to explain the Lord Dennin's in a explanation here. As per Lord Dennin, the object of the remedy is to bring to an end the matters complained of, that is the oppression, and this can be done even though the business of the company has been brought to a standstill. If a remedy is available when the oppression is so moderate that it only inflicts wounds on the company whilst leaving it active, so also it should be available when the oppression is so great as to put the company out of action altogether. Even though the oppressor by his oppression brings down the whole edifice, destroying the value of his own shares with those of everyone else, the injured shareholders have, I think, a remedy under section 210 of the then prevailed Companies Act 1948. Now I come to the Sri Lankan law in answering our question as to who has the right to file an action in a case of oppression and mismanagement. As per section 224 of the Companies Act number 7 of 2007, any shareholder or shareholders of a company who has a complaint against the company that the affairs of such company are being conducted in a manner oppressive to any shareholder or shareholders, including the minors, including the shareholder or shareholders with such complaint, may make an application to the court for an order under the provisions of this section. So, it could be by way of the management, including directors or shareholders or both. As per section 226, an application under section 224 operation or section 225 mismanagement may only be made by a shareholder or shareholders, only the shareholder or shareholders, who at any time during the 6 months prior to the making of application constituted not less than 5% of the total number of shares. So, who at least have 5% of the shares during the last 6 months to the time that they are filing now the case, or held shares which together carried not less than 5% of the voting rights at a general meeting of the company. I mean, when several shareholders are coming together, then all such cumulative total exceeds 5% of the voting rights at general meeting of the company. So, those are the shareholder or shareholders who are eligible to bring an action under 224 or 225. As per section 225, any shareholder or shareholder of a company having complained that the affairs of the company are being conducted in a manner prejudicial to the interest of the company, or that a material change, not being a change brought about by or in the interest of any creditors, including debenture holders or any class of shareholders of the company, has taken place in the management or control of the company, whether by an alteration in its board of directors or of its agent or secretary, or in the constitution or control of the firm or body corporate acting as its agent or secretary, or in the ownership of the shares of the company, or in any other manner whatsoever, and that reason by such change it is likely that the affairs of the company may be conducted in a manner prejudicial to the interest of the company, may make an application to court for an order under the provisions of this section. So, this is the answer. This answer can be written in an essay form like this, or in the nature of a point form answer, whatever, does not matter, but what matters is that you provide the proper answer to the question based on the statutory provisions, the Companies Act. You have to make sure. Now, the next question is, Nimali, the secretary of XYZ Limited, was asked to call the annual general meeting AGM of the company for the year 2019. In every year, the balance sheet date of the company is 31st March, or the what we call the end of the financial year is 31st March and the commencement is 1st April. The AGM for the year 2018 was held on 31st of May 2018, and accordingly Nimali had scheduled to hold the AGM of the company on 30th July 2019. At the AGM, a shareholder, Mr. Pereira, had questioned the legality of the duration of the AGM for the year 2019, whether the AGM was held on time or within the prescribed time as per the Companies Act. So, what you are required to do is to explain whether the company legally held its AGM for the year 2019. Now, in the answering, this is quite logical, unlike the other answers that I discussed, because it deals with a certain date and time period which the Companies Act has duly provided the proviso in determining the date or the time period within which an AGM of a company should be held. Now, as per section 133, an annual general meeting of shareholders to be held once in each calendar year, not later than 6 months after the balance sheet date of the company and not later than 15 months after the previous annual general meeting. So, now what here it says is not later than 6 months after the balance sheet date of the company. So, here the balance sheet date was 31st March. So, after the 6 months period means it goes up to September, end of September. But it says also and here, not or but and not later than 15 months after the previous annual general meeting, which means that previous annual general meeting was held in May, 31st of May 2018. So, 15 months from May 2018 is August, before the 31st of August, before the 31st of August. So, it should be correctly to say before 31st of August it should be held, even though the balance sheet date might give you up to 30th of September. If it is the first AGM to be held, then it shall be held within 18 months of its incorporation. So, if it was the first AGM, then it allows you to have the first AGM after 18 months from the date of incorporation. Where default is made in whole in an AGM, the registrar may on the application of any shareholder of the company call or direct the calling of an annual general meeting of the company and give such ancillary and consequential directions as the registrar thinks expedient. Therefore, the holding of the previous AGM was 31st of May in this particular case 2018, whereas the balance sheet date of the company fell on the 31st of March each year. The next AGM should be called before the expiration of 6 months of the balance sheet date or before the lapse of it should be N before the lapse of 15 months from the date of the last AGM, which falls before 30th of September and 31st of August respectively. But since it says N, it should be held before 31st of August 2019. Since the new AGM is scheduled to take place on the 30th of July 2019, it is therefore valid as per both, not either, both of the stated time periods fall within such time of the AGM to be held. So, this is how you need to cover such a logical answer. Now, from there onwards, I want to discuss with you all this question paper. I am not expecting to give you the written forms because I have differently approached different answers, and some of these I have covered in my lecture series, which I would now take you through. Now, this same question I did in my presentations, lectures, and the second one, task 2, which is the same as what I had referred in that question. Nilmini, the secretary of the company, further has following questions to you. The duration of notice of annual general meeting to the shareholders. What should be the duration? Then the second, how company can validate an AGM which is called by a shorter notice to the shareholders. Thirdly, the duration of notice of an extraordinary general meeting. to the shareholders of a public company, and then how company can validate an EGM which is called by shorter notice to the shareholders. Require advise the secretary by considering the provisions of the Companies Act. Now, in the first one, where the question is the duration of notice of annual general meeting to the shareholders. A notice of AGM is to be given to every member of the company at least 15 days before the meeting, as per the section 135 of the Companies Act. 15 days prior to an AGM to be called, notice need to be given to the members of the company. Secondly, how company can validate an AGM which is called by a shorter notice to the shareholders. I mean, where an AGM has been called less than 15 days from giving the notice. Then, if a meeting is called as the AGM by a shorter notice, and if all the shareholders who are entitled to attend and vote at such general meeting, so agreed to call the meeting by shorter notice, the AGM is deemed to have been duly called. So, if all the members who are entitled to attend and vote a general meeting has no objection as to the calling of an AGM with a shorter notice, then it can be dispensed of. The shorter notice, the giving of a shorter notice can be dispensed of by obtaining the no objection of those who are entitled to vote at a general meeting. If there is no objection by any one of them, then the AGM can be deemed to have been duly called. Thirdly, the duration of the notice of extraordinary general meeting or EGM to the shareholders of a public company. Generally, to call an EGM in a private company, 5 working day notice should be given by the director. So, it is a short time given by the director. In a public company, 10 working days notice be given. However, the AGM, if any special resolution is going to be passed, if any special resolution is going to be passed at the EGM, then not less than 15 working day notice shall be given in respect of both the private company as well as a public company. So, 5 for a private company, 10 for a public company, and if a special resolution is to be passed at the EGM, then 15 working day notice shall be given in both scenarios. Fourthly, how company can validate an EGM which is called by a shorter notice, shorter than that. If a meeting is called as the EGM by a shorter notice, that is shorter than 5 in a private, shorter than 10 in a public, or shorter than 15 in case of a special resolution. And if the shareholders together hold in not less than 95% of the voting rights who are entitled to attend and vote at such general meeting, so agree to call a meeting by shorter notice, that is enough. If consent of at least 95% of those who have the voting rights at general meetings have consented to, then the EGM is deemed to have been duly called. Now we go back to the question paper. Now in this question, Dhanapala, creditor of ABC Private Limited, had demanded his money from the company, but the company had neglected to pay the money up to date. Therefore, Dhanapala is seeking the possibility to wind up the company by court. Now, what is the question? Dhanapala is a creditor, and now company has failed to settle this creditor, or the company has rather neglected to pay the money up to date. Therefore, now Dhanapala is seeking the possibility to wind up the company by court, not a creditor's winding up, but a winding up by court. So he is going to be the petitioner. Dhanapala is going to petition to the court to wind up the company. In the winding up of companies, we discuss about the winding up by court. So what you are required to do is advise Dhanapala stating under what circumstances he may make an application for winding up of the company and state the consequence of such compulsory winding up order. So here we need to go to our presentation where we were doing on company winding up, and especially the case of winding up by court. And what are the requirements in winding up by court? Now here a creditor wishes to be the petitioner in the winding up. Now winding up by court. As per section 270, a company may be wound up by court. If the company has by special resolution resolved the company be wound up by court, or the company does not commence its business within a year from its incorporation or suspend its business for 1 year, or if the number of the company members falls below the minimum number required under section 2, section 4 of this act, the company has no directors or the company is unable to pay its debts, and that is where now Dhanapala is going to fit in. The company is unable to pay its debts. So Dhanapala, being the petitioner, has to prove to the court that the company is unable to pay its debts, and so it has failed to pay its debt. Then further clarification. A company shall be deemed to be unable to pay its debts where a creditor by assignment or otherwise to whom the company is indebted in a sum exceeding 50,000 rupees then due has served on the company by leaving it at the registered office of the company, deemed under his hand, requiring the company to pay the sum so due, and the company has for 3 weeks from the date so leaving neglected to pay the sum or to secure or compound for it to the reasonable satisfaction of the creditor. So either Dhanapala has made such a thing, or execution or the process issued on a judgment, decree or order of any court in favor of a creditor of the company is returned unsatisfied in whole or in part, or it is proved to the satisfaction of the court that the company is unable to pay its debt, and in determining whether the company is unable to pay its debts, the court shall take into account contingent and prospective liabilities. So Dhanapala fit in again here, where he should prove to the satisfaction of the court that the company is unable to pay its debts. So you need to explain this part as well as this part in justifying or providing a proper answer to your court. And an application to the court for the winding up of a company shall be by petition presented subjected to the provisions of this section. This is what Dhanapala has to follow, either by the company or by any creditor or creditors. So Dhanapala fits in, including contingent prospective, here contributory means, so about the shareholders. And then your next question is, what would be the effect of such a winding up? So effect, this is the procedure we have discussed. So here The court may at any time after making the winding up order require any contributory for the time being on the list of contributories, any trustee, receiver, bank, agent, officer of the company to pay, deliver, convey, surrender or transfer forthwith or within such time as the court directs, liquidator any money, property or books, papers in the hand which company is prima facie entitled. The court may, in the event of the assets being insufficient to satisfy the liabilities, make an order as to the payment out of the assets of the costs, charges and expenses incurred by the winding up in such order priority as the court thinks just. So the court has to thereafter make such orders, and then the company will be dissolved in such a manner in that. State the consequences of such compulsory winding up order. That is what we discussed. Then section 4. Now, according to the articles of D&I Limited, the object of the company is manufacturing, selling books. According to a recent survey, manufacturing of lead bulbs is profitable than manufacturing books, but the directors of the company are not aware of the legality of the contracts which are not authorized by the articles of required advice of the directors of the D&I Limited. This case also we did in our presentations, you may remember. With regard to articles of association. You see, we have discussed this same thing. According to the articles of association of D&I Limited, the object of the company is manufacturing and selling books. According to the articles, the object of the company is manufacturing and selling books. According to a recent survey, manufacturing of lead bulbs is profitable than manufacturing books. But the directors of the company are not aware of the legality of the contracts which are not authorized by the articles of association. Therefore, whatever not authorized by articles of association, what you need to do is then to amend the articles of association and do it. So, let us look at how the company articles could be altered. Now, in altering, the articles of association shall be adopted by special resolution of the company, and where a company by special resolution alters its articles, it shall give notice of such resolution to the registrar within 10 working days with new articles, if any. So, if the book business is not profitable as LED bulb business, then to do LED bulb business and getting into contracts of such, then the articles need to be altered and properly informed duly to the registrar of companies. This is what you got to state in your answer. The articles of a company shall bind the company and its shareholders as if there were a contract between the company and its shareholders, unless there are anything to the contrary where that resolution or the holding of those shares would increase the liability of the shareholder to the company, unless the shareholder agrees in writing to be bound by resolution or to accept the shares as the case may be. So, there are 4 articles of association that forms the constitution of a company, must be so expressed, and nothing can be done in violation of the articles, and if anything to the contrary to the articles need to be done, then you got to alter the shares, alter the articles. The next question is articles of ABC Private Limited set out very member is entitled to cast 1 vote per share. Ranjit, a member of the company, holds 100 shares of the company. However, at a general meeting, the chairman of the meeting refused to recognize his 100 votes. Ranjit filed an action for damages on the basis of breach of contract between himself and the company. Edmund, a lawyer, was appointed by the Articles of Association of ABC Private Limited as the company lawyer for life. After some time, Edmund was reviewed from the post. Edmund is going to file an action for damages on the basis of breach of contract by the company. Require advice the directors of ABC Private Limited in both these circumstances. In both those circumstances, you see, this carries entirely 10 marks. So, you need to appropriately answer this, and I have done so. I have discussed that in during your lectures. You see, I have discussed the same thing and explained to you all that with regard to the second one, the Articles of Association of ABC Private Limited set out, every member is entitled to cast 1 vote per share. So, that is the law of the company. Ranjit, a member of the company, holds 100 shares of the company. However, at a general meeting, the chairman of the meeting refused to recognize his 100 votes. Ranjit filed an action for damage on the basis of breach of contract between himself and the company. Now, I have told you before that a company articles operate as a contract between the company and its shareholders. So, therefore, whatever the articles has provided to the shareholders, that he is entitled to. It is a breach of contract for the shareholder. So, you need to give an explanation with respect to that area. Secondly, an Edmund, a lawyer appointed by the Articles of Association as the company lawyer for life. After some time, Edmund was removed from the post. Edmund is going to file an action for damages on the basis of breach of contract by the company. Now, here the lawyer has been appointed by Articles of Association. So, without altering the articles, you cannot remove him or remove his entitlement as to the lawyer for life. You need to alter by special resolution and thereafter effect such a removal if you require. So, this is how you got to explain, but you need to explain in detail if you want to get good marks, because you see that it has 10 marks altogether. Then question 7, Raman, the promoter of the company, entered into a contract with Silva to purchase furniture for the future company. After the company was incorporated by name ABC Private Limited, however, the company refused to ratify the pre-incorporation contract and contended that a company cannot ratify its pre-incorporation contracts. Because of the contention of the company, the seller Silva is confused with how to collect the price of the furniture. Required to address the seller as to whether the contention made by company is correct and how can recover money accordingly. Now, I have discussed with you on this area under the promoter of the company, and here to task 3, where we have discussed the same question in our lecture, and what relates to is the company contracts and the promoters. So, pre-incorporation contracts that we discuss. Pre-incorporation contracts. Pre-incorporation contracts are those contracts purported to be made on behalf of a company, entered before the incorporation of the company. These are generally brought about by the promoter who intends the formation of such company, who is thereby obligated to bring the company in the legal existence and to ensure its successful running. And in order to accomplish his obligation, he may enter into some contract on behalf of prospective company. Nature of incorporation contract is slightly different to the ordinary contract. Nature of such contract is bilateral. B, it has the features of tripartite contract. That means the promoter, the company to be, and the third party. In this type of contract, the promoter furnishes the contract with interested person, and it would be bilateral contract between them. But remarkable part of this contract is that this contract has the perspective company which is not party to the prospective company, which is not party to the contract. As per now, this is the Sri Lanka's legislative enactment in such area, because I told you about the Kellner versus Baxter case, which is a common law case where I did not allow here such incorporation, pre-incorporation contract to be valid, and I have given several case law here. So, you got to explain all these things in your answer. As per section 23(1), the expression pre-incorporation contracts means this: and also about section 23, that the pre-incorporation contract may be ratified with such period as may be specified in the contract, or if no such period is specified, within a reasonable time after the incorporation of such company in the name of which, on behalf of which it has been entered into. So a pre-incorporation contract that is ratified shall be valid and enforceable as if the company had been a party to the contract, as the normal contract after incorporation of the company at the time it was entered into, and such ratification is valid when it is ratified by a company in the same manner as the contract may be entered into on behalf of the company. So I have given you a certain case law, English case law, and stated that also this case law, common law case law position has now been altered in Sri Lanka's company law, that the pre-incorporation contracts are valid thereby under statutory law. So this is how you got to explain your answer. You need to write all these full details if you are to gain more marks out of the 10. Then of course the last question, yes, the last question. The shareholding of XYZ Private Limited is consisted of both redeemable and ordinary shares. Further, the company had contracted in writing with creditor by agreeing that the company will not reduce its share capital more than 5% without the prior consent of the creditor. You are required to advise on the procedure of redemption of redeemable shares and the procedure of reduction of share capital. Now that question also I did in the lectures, and I will show you where I have done that. Here, the same question. So the shareholding of XYZ Private Limited is consisted of both redeemable and ordinary shares. Further, the company had contracted in writing with the creditor by agreeing that the company will not reduce its share capital more than 5% without prior consent of the creditor. The procedure of redemption of redeemable shares. The procedure of redemption of redeemable shares I have discussed. First of all, you have to discuss what is a redeemable share. What is the redeemable? What is a redeemable share? Shares issued on terms that company will or may buy them back at some future date. The date may be fixed or at director's discretion. The redemption price is often the same as the issue price, but need not be. Often done with non-voting shares given to employees, so that if the employee leaves the company, his shares can be taken back as normal value. There are statutory restrictions on redemption of shares. Share is redeemable if the articles of the company make provision for the redemption that share by the company at the option of the company or at the option of the holder of the shares, or on the specified date in the articles for consideration that is specified or be calculated by reference to formula or required to be fixed by suitably qualified person who is not associated with interested income. Then a company may exercise an option to redeem share which is redeemable at the option of the company if the board has previously resolved that the redemption is in the interest of the company. Redemption of the share at the option of the company is deemed to be an acquisition of the company share distribution. Now thereafter, the procedure of reduction of share capital is also I discuss. The procedure on redemption of shares, section 67, 68, 69, you got to write these things if you want good marks to your answer in your question paper. So the procedure on the redemption of shares, you can follow this and you can write your answers after explaining what are those redemption shares. Then go to the next one on the procedure on reduction of share capital, section 59, which I have also discussed with you in my lectures previously in this area. So you just got to follow these questions, these answers as per I have given, and you got to write in detail. So that's about the entire discussion based on our model paper. I hope that you have got a very good understanding on how to write your answers, and I'm sure that you can provide all the answers as per the lecture series that I have conducted, and be well planned for the exam. So let me thank you for listening to my lecture series, as well as the final session that I did today on the model paper, taking out the questions and giving you tips and guiding you through how to answer the questions in order to get more marks and pass your exam with colors, I should say, especially in the paper of CL4 corporate law. You must provide some good answers as explained here with full details. That is what is expected out of a law paper in general. So thank you very much again for attending my lectures, and I wish you all the very best and success in your exams as well as in all your future endeavors. Thank you.